Good morning, everyone, and welcome. We're going to get started in another minute here, but slides for today's presentation are available in the chat window. You can jump to that link and download the slides, and they'll also be provided to you by email after the presentation. Good morning and welcome to today's presentation, 2021 Legal Year in Review. This is the main portion of our presentation. When I say main, I don't mean the primary, but I mean the state of Maine. So this morning, right now, we're doing the main presentation, and we're also going to have discussions about national law updates and changes. Later today, we'll have the Massachusetts update and the Connecticut update. You can use the same link to access each of those presentations. My name is Tani Alvarez. For those of you who don't know me, I am a partner in Veryl's Labor and Employment Practice Group, and I'm excited to be with you here today to share lots of new and interesting and ever-changing rules and laws that occurred throughout 2021 and what we can expect for 2022. You'll see the materials for today's presentation in the chat window. Please use the chat if you have questions throughout the course of the presentation. I'm going to be taking a look at it, and I'll attempt to answer your questions as we're moving through the presentation topics. Because this is a mix of all the things that have happened in 2021, it's usually best to ask your questions when we're talking about the topic at hand. However, if we get to the end and there's time, you can ask those questions as well. We are recording today's presentation. You'll see the little record button in the top. We will be sending out a copy of both the presentation as well as this recording after today's presentation. I invite you to join us on February 17th at 9:30 for a presentation entitled Romance and Relationships in the Workplace. And that's going to be presented by Elizabeth Smith and Elizabeth Johnston. And that will be the second part in our 12-part series for this year's annual update, which for the second year we are doing virtually as opposed to in person for health and safety concerns. So with that, let's get started because we do have a lot of information to get through in the next hour. And for those of you who have joined me in presentations in the past, you know that it's important for me to make sure I communicate to you what you're going to get out of today's presentation. So a brief outline of what we're going to be talking about today. First, from a state law standpoint, we're going to be talking about the earned paid leave law. We're going to be talking about 2021 legislative updates to the Maine Family Medical Leave law, as well as discussion about expectations in 2022. We're also going to talk about some legislative changes to a wage payment and payroll changes that you should be aware of. We're going to talk about the new Maine statute concerning fair chances in employment. We're then going to talk about some industry-specific legislative changes to be aware of. Then we're going to jump into some discussions concerning the Whistleblower Protection Act and some case law that came down in 2021, and then some amendments to the Maine Human Rights Act that took effect in 2021. We're then going to hop over and talk about the larger, broader national updates, and here we're going to talk about COVID-19. We've all been talking about it, but a really brief update as to where we find ourselves. And then we're going to talk a lot about employee mobility and the Great Resignation and work from home and legal challenges you may be facing. And if we have time after all that, we're going to do a brief update on the National Labor Relations Act. So with that, let's jump right into our state update. Now, a lot of things happened at the state level. I know that we've been focusing a lot on health and safety as it relates to COVID, but throughout all that time, we continued to see the legislature moving bills forward. So the first thing I want to talk about is Maine's earned paid leave law. And I'm sure a lot of you are sitting here saying, Tawny, it's 2022, not 2021. You talked about this in 2021. Why are you talking about it again? Well, here's the thing. When this law went into effect on January 1st of 2021, there was a lot of misinformation, I guess, regarding the bill itself. There was a lot of questions that remained about how the statute was going to be interpreted, how the Department of Labor viewed different terms within the statute itself. And we were seeing amendments and additional guidance as to the bill all the way through kind of February of 2021. After that point, the question really became, how do we institute this new law within our workplace? There continues to be significant confusion concerning the interrelationship with the earned paid leave law and current PTO policies. And the primary place we're seeing confusion is at the rate of pay in which wages are paid out. A lot of employers who previously had PTO policies that were more robust or provided more than 40 hours a year of leave thought, and I can understand this belief, that they didn't have to do anything because they were already providing more benefits than was requested. But the statute has elements in it that most employer policies don't include. And one of those is determination of what the regular rate of pay is. So you have to look back at the previous week to determine how much money was paid to the employee to determine what the new rate of pay will be for any time taken concerning earned paid leave. So while the employee may make $25 an hour, okay, normally for regular vacation or PTO, when a person takes PTO, they're going to be paid at $25 an hour. But for our non-exempt hourly employees, if the week prior to taking the leave, they received a bonus or they received some type of attendance, it's usually a bonus or some type of additional compensation for that week, it's going to change the regular rate of pay, and potentially in the week in which they take earned paid leave, they might need to be paid out at $27 an hour or $26 an hour. So just be mindful of that. Another issue that we've seen a lot of questions concerning is blackout periods as they relate to requests for leave. And we've seen a lot of employers who are attempting to block out the whole summer. That's not going to be permissible. We're going to need to be able to show kind of reasons why. It might be for a weekend that we have a blackout period. It may be that only 2 or 3 people can take leave during a specific time period, and once 3 people have taken leave, then it's a blackout period. Those type of rules will be permissible, but simply saying every weekend or all summer long, it's going to be overbroad. The other thing that we're seeing is the relationship with attendance policies, and oftentimes employers have policies in place that say that if an employee is late or if an employee is absent from work, that it's kind of a strike under their attendance policy. And after 3 strikes, they move down a provision within their yearly or annual review performance documents, or we'll have attendance bonuses. So if somebody takes earned paid leave during that period of time, it can't be counted as an absence, and the individual would still be entitled to an attendance bonus. So making sure that you understand the rules regarding earned paid leave as they relate to all of your existing policies is really important. And if any of this is news to you, I invite you to contact any member of our team to have a discussion about how to interrelate your current policies with the statute. I would also recommend visiting the Maine Department of Labor, frequently asked questions concerning these types of issues as well, because there's a lot of good information there. So that's just a quick update on earned paid leave. Let's talk about the main family medical leave. Now, we know that the current statute applies to employers who have 15 or more employees, okay? This year, or 2021, it was amended to include grandchildren and a domestic partner's grandchild. So the statute now reads that an individual can take FMLA leave for the serious medical health condition of a child, domestic partner's child, grandchild, domestic partner's grandchild, parent, domestic partner, sibling, or spouse. Now, it was not amended to include employees' ability to take FMLA to care for a grandparent. So it's only the other way around, where an employee who is a grandparent can take time away from work to care for a grandchild, okay? This is signed into law on July 22nd. So that was what the amendment that we saw. And we're going to talk about some additional amendments that are coming down the pipe right now in 2022. So we have a bill right now before the legislature that is attempting to broaden the definition of domestic partner to include generally two individuals who financially rely upon each other. Now, this is so broad that it doesn't involve or include any type of romantic relationship between the two individuals. So two people living together as roommates who rely upon each other financially because they either both signed the lease or they split the rent, that would then be considered a domestic partner. The Maine Chamber of Commerce and a number of other policy organizations are really lobbying to tighten that definition so that it's the same as the statutory definition of domestic partner. So there's a chance that in 2022, we're going to see a further expansion of the Maine Family Medical Leave Law. Now, this is all happening while simultaneously we have the working group that was funded in the 2021 legislative session, and it's LD 1559, and it was signed on July 22nd of 2021. And what it did is it created a paid family medical leave working group, and $200,000 was provided to the group. And the commission, it was tasked with researching and understanding whether or not the state was in a position to develop a paid family medical leave benefit program. And there ended up being on this commission 2 members from the Senate, 2 members from the House of Representatives, 2 members that were appointed by the President of the Senate, which included a labor representative and a representative of an employer with 50 or more employees. And then 3 members who were appointed by the Speaker of the House, including expert on family medical leave benefits, an employer with less than 50 employees, and an employer in the hospitality industry. Now, last week, the working group had its last meeting, so we are expecting a recommendation to be provided publicly shortly. Right now, based off of the questions and the things that we heard at the working group, it's expected that they're going to recommend a paid family medical leave program, but that it would be funded more by employees from a tax perspective, but that there would be some employer portion. So keep your eyes and ears open for that recommendation from that working group, because it will have an effect on how we deal with family medical leave as we move forward. Massachusetts instituted the practice a couple of years ago. Connecticut's Paid Family Medical Leave Act went into effect this year on January 1st of 2022, and it's likely that we'll see elements of both of those programs that will be incorporated into Maine. So that is, a brief outline of what we're seeing from a family medical leave perspective. This kind of leads to a case law update, and the case law is concerning pregnancy discrimination. And I wasn't going to include this, but I think it's interesting because I foresee us seeing another amendment to the Pregnancy Discrimination Act under Maine law. So the case is Ouellette v. Francisca's Collection. It's a District of Maine case that came down on November 30th of 2021. And the employee was terminated and filed a claim under the Pregnancy Discrimination Act, but didn't include any claims under the Americans with Disabilities Act. And here, the District of Maine, a motion to dismiss was filed, and the motion to dismiss as to the Pregnancy Discrimination Act was granted. And within it, you'll see this language that says, while an employer must offer reasonable accommodations, such as temporary modifications in work schedules for pregnant employees who are otherwise able to work, maternity leave is not an accommodation. Now, this ruling is similar to the case in 2017, Carnicella v. Mercy Hospital, where the court there found that a leave of absence was not a reasonable accommodation. Now, in 2019, the legislature amended the Maine Human Rights Act to include leaves of absences as a reasonable accommodation. It's unclear why plaintiff didn't file an ADA claim, which then I think could have argued the leave of absence as a reasonable accommodation. But here, I would suspect that we will see a legislative amendment or attempt to amend the Pregnancy Discrimination Act to include leaves of absences. But something to be aware of if you're currently dealing with maternity leaves or the Pregnancy Discrimination Act, this case, with the understanding that while they're saying it's maternity leave is not an accommodation under the Pregnancy Discrimination Act, we need to be mindful that under the Maine Human Rights Act or the Americans with Disabilities Act, that a leave of absence may in fact be a reasonable accommodation. So there hasn't been a ton of cases that are relevant to today's presentation that significantly change the law in Maine. So we're kind of throwing in a couple of them that you need to be mindful of. But the biggest reason I think to be mindful of it is to understand legislatively what we most likely are going to see in the next 12 months. Let's jump and completely shift focus to payroll and wage issues. So kind of wage and hour concerns specifically. So in 2021, we saw an amendment to Section 635, which is overcompensation by employers. Now, previously, hopefully, you've never had to deal with this statute, but what the statute itself provides is that if an employer overcompensates an employee, so let's say when you are putting your wage rate into your payroll program, you type in $23 instead of $20.30, and then you find out 2 weeks later that you've been overcompensating the employee. You have the ability to obtain that money back, okay? You continue to have the ability to get that money back, but there's been changes in the process and what is considered wages. So here, if the overcompensation occurs because you've improperly determined what the rate of pay is for an employee's earned paid leave, you can't get the money back. So this goes back to our first slide when we were talking about the difficulties in determining what the regular rate of pay is for earned paid leave. This statute now says earned paid leave can't be a form of overcompensation. So if you screw up that number, too bad, you can't get the money back. Okay, so it's going to include paid leave as well as, awards, bonuses, settlement, fringe benefits. All of those previously had been included, but now we have this inclusion of paid leave benefits. Additionally, we have a change in the statutory ability to go back in time. So previously, you arguably could have gone back in time as far as you'd been overcompensating the individual. Now you can't go back more than 3 years. So as to the overcompensation, you can look back 3 years. And if you've been overcompensating the individual for more than 3 years, you're only going to be able to withhold or recover the last 3 years. We also have a provision that decreases the amount that can be withheld. So previously you could withhold up to 10% of the net wages. Moving forward, however, 2021 forward, you can only withhold 5% of the net amount. We also saw an amendment to 26 MRSA, section 621A, subsection 7. And it's an additional provision that says you cannot charge a fee for direct deposit. Honestly, this amendment doesn't significantly change the law, as there previously was language that was read to provide that if you do provide direct payment, direct deposit, that there can't be charges or fees associated with it. So if you only permit direct deposit, you have to do it in such a way in which the individual can easily access without fees or charges that money. So this is kind of an additional or clearer indication of that intention by the legislature. The biggest amendment to main employment law, I think, in 2021 is as to employment applications. And that was an amendment to 26 MRSA 600-A. And that was, or is, an act relating to fair chance in employment. So this act relates to all, or applies to all employers across the state. So except for, and this is unsurprising, except for the legislative, the executive, and the judicial branch of the state. So you have 1 employee, you have 400 employees, this applies to you. What it provides is that an employer cannot request criminal history information on an initial employee application form. And you can't state on an initial application form or an advertisement or specify in any way prior to an offer that a person with a criminal history may not apply or will not be considered for a position. Now that's really broad in that anytime prior to an offer, you can't indicate that a person with a criminal history can't apply or won't be considered for a position. Now, in the same vein, right, it's specific in that it says criminal history can't apply or won't be considered for a position. Now, it doesn't identify that you can't say a background check will be required. And there is an exception where you could inquire on the application form or state an individual will not be considered if, based off a state or federal law, the individual would be disqualified based off of the previous convictions. And the document states very specifically what those limitations or disqualifying offenses would be. So it's important that we pull out, so what is our kind of takeaway from this? We need to review our employment applications. And if you've been to any of my previous presentations, you know that I say yearly. This is something that we should be doing, is pulling out that application and making sure that there aren't concerning provisions or language that is included in the document, either based off of kind of evolution of state and federal law or evolution of your work environment. That's the first thing. The next thing is we need to talk to anyone who participates or is part of the hiring process, because there are limitations to the discussions at an interview. So you can inquire about criminal history once an individual is determined to otherwise be qualified for a position. And if the employer does inquire, the applicant must be afforded the opportunity to explain any conviction information and the circumstances surrounding both the conviction and post-conviction rehabilitation. Now, here's the problem with this and why I would ask that we continue to have interviewers not ask about criminal history, and we wait until after an offer letter has been provided. What is the determination that someone is otherwise qualified for a position? So one person may think that the individual is qualified, but another person may not, okay? So the ability to determine whether or not an individual is qualified for a position in a lot of situations isn't going to be just based off of what the application says, but additional aspects, especially considering how many jobs or job descriptions, at least that I see, that discuss about the ability to work well in a team or communicate effectively as being qualifications that are necessary. And those are things that are difficult to see just on a paper application or on a resume. So it's important that we train our interviewing employees and managers as to best practices here about inability to kind of discuss criminal history. And one of the ways in which I see this most often, because I'm sure you're thinking, well, Tani, none of our managers are silly enough to say, so you ever done time, or tell me about why you're here. Instead, we see this a lot when there's gaps on resumes, where there's a gap and a manager is going to ask about the gap, and we learn or determine that there is some type of conviction or the individual has been incarcerated for a period of time. So working with your management team as to this statute and how to reduce risk is really important. Let's jump to some very industry specific legislation, and I'm not going to spend a ton of time here, but I do want you to be aware of it because of how broad it is, and to get a sense of what we're looking at potentially in 2022. So one, there was an amendment for employees who are emergency medical services personnel. And that is not just individuals who work as EMSs as their paid job, but also volunteer EMSs. And what it does is it amends Section 809 to include EMS personnel in addition to firefighters. And what 809 does is it prohibits discharge or discipline for employee absences that are based on the emergency work. So if an individual is unable to arrive at work on time, has to leave earlier, is absent, and the reason for that is because they're a firefighter and EMS personnel, you cannot discharge or discipline the individual for that absence. This would be another situation where you need to understand your employees and what they do outside of work if they are EMS providers, and then make a notation within their file that you're not holding any tardies or absences against that individual if the tardies or absences are based off of their work as an EMS or in the healthcare language. So one of the questions that we had regarding the employment applications, and this relates honestly partially to this EMS question, is do I have sample language or wording for healthcare employers who can ask certain criminal conviction questions on the applications or under accepted exceptions? So what we would need to do is for the healthcare entity, we'd need to see what licenses or restrictions that they have. So there's some that, CMS may have obligations that provide that you cannot, hold this position if you have a conviction within the past 7 years involving bodily harm. Or there's in the banking industry, if you have convictions within a period of time involving theft or dishonesty above a certain amount of money. So we would need to so the first step would be finding out what the disqualifiers are. And then if you're going to include that on the application, you very specifically we'll need to include that language on either the application or on the job description. Now, I would recommend including it on the job description and providing it to the employee upon them either coming in for an interview or at the offer letter time. So when an offer of employment is made. If you do choose to include it on the application or in a job posting online, we have to be very specific. And I would recommend saying, not that they won't be hired, but that a background check is going to be performed, and that under contractual provisions, you know, these are limitations on our ability to hire. Can we go back to the last slide about employment applications? Because we have a couple of more questions regarding this. So another question is, can you include an initial release to do a background check to determine criminal history with the application? So you can, but you're not going to want to do that background check until you've made the conditional offer of employment. So if you're doing, you shouldn't be doing background checks before a conditional offer of employment is made. So if you have individuals who are applying to a position online and part of your application process is going to include a background check, you can include in there the waiver language if you're using specifically a third party provider that includes the full release under the Fair Credit Reporting FCRA requirements for any background check. So you would include that release, but you're not going to perform or advise a third party to perform that background check until it's been a conditional offer of employment has been made to the individual. Another question concerning the employment applications: federal Head Start and state rules for licensing of child care facilities prohibit hiring people who've been convicted of very specific charges, and it's a very long list. You have to list everything. Yes, you would have to include everything under this law, okay? And that's one of the reasons why I don't think it should be on the application form. I think that it's something that should be a separate document after we've already gone through the process of interviewing. And a lot of people push back on me on this and say, well, that's just a waste of time then, Tawny, because we're going through the interview process where we've made the conditional offer, and then we find out that the individual isn't qualified because of these prior convictions. Understood, but the way this statute is written, it's so broad that if you're not including every single reason and then providing the ability to discuss it afterwards, you're likely going to have someone who's going to argue, well, I'm otherwise qualified, and the reason you disqualified me was because of this previous criminal history, and I didn't fall within the statutory terms because there's always going to be these other aspects. When we're looking at conviction documents, it's very rarely clean cut. It's very rarely clearly within the provisions, and there's a lot of different background information that we potentially need to make a determination as to whether or not they truly are foreclosed. In the banking industry, in 2020, we saw an amendment to the law again, that even if someone does have a conviction that previously would have disqualified them, they potentially may not be disqualified if you can show a number of different factors. It's a much more nuanced application in many industries, and that's why I think waiting until you're further along in the interview process makes sense. Another question: do we have to advise that a background check will be conducted prior to starting the employee if offered? we have to advise that a background check's going to occur prior to a background check occurring, and best practice would be to get a written release. Even if you're doing it yourself, so that it isn't a background check under the FCRA. So under the FCRA, we know that if a credit report, which is very broadly defined and includes criminal history, if one of those is being conducted by a third party, that we need a written release that's very specific, where we're going to provide the employee with background information. If you're using a third party in any way, you should get a written release. And I recommend getting a written release even if you yourself are just making phone calls to individuals about background or to confirm employment, so that you have the ability to say to those employers, yes, they've given me permission, and you're not just using information from the application to go around and seek additional information concerning these applicants. So I would definitely always recommend advising people that a background check is going to be performed. You can do it in the application itself, but you just can't say that individuals with criminal histories will be foreclosed or won't be hired. You can say a background check is required, and leave it at that. Okay, lots of questions there, and it was a big kind of change, not change, but a big change to the statute. We'd seen a lot of states that had issued, this is called ban the box legislation. This is a form of ban the box legislation. And we'd seen an attempt to have ban the box legislation in 2014 approximately, and only recently kind of did it pass. So let's jump back to the industry specific legislation. We talked about emergency medical services. In the construction industry, if you operate in the construction industry, we now have mandatory safety training for construction workers. Specifically, those employees will be required to complete a construction safety training program that uses a curriculum that's approved by the United States Department of Labor, OSHA, and it has to be at least 10 hours in duration. In addition to the training itself, at every job site, you're going to have to post an affidavit that says that you meet the requirements at each of those job sites. We also saw an amendment to the tipped employee statute. So previously, in order to use the tip credit, a tipped employee was defined as an individual who regularly receives more than $30 a month in tips. Now that number hadn't been amended for a significant period of time. As of January 1st of this year, the definition was amended to provide that it's $100 or more a month in tips. And in 2023, it'll be amended to be $175 or more a month in tips. And then in 2024 and moving forward, it'll be increased based off of cost of living every year moving forward. So that's an industry specific update. Let's talk a little bit about Maine's Whistleblower Protection Act. So this year we saw a case, Nadeau v. Twin River Paper Company, LLC. And in that situation, we have an employee who makes a claim under the Whistleblower Protection Act. And we have at Twin River Paper Company, a collective bargaining agreement that sets forth rules governing employee conduct, safety policies, and disciplinary procedures. So the question before the court was whether or not the employee or the plaintiff's claim was preempted by Section 301 of the Federal Labor Management Relations Act and Section 837 of the Whistleblower Protection Act. Now, the Labor Management Relations Act, remember, is a federal law that provides that if we need to analyze in some format a collective bargaining agreement, then it preempts any state law or state rules, because the collective bargaining agreement is supposed to be seen as overriding or preempting any other laws. So here the court found that plaintiff's claim was preempted by the combined effects of Section 301 of the Labor Management Relations Act and Section 837 of the Whistleblower Protection Act. The law court affirmed the lower court's ruling, and the determination of whether a claim is preempted by the Labor Management Relations Act is whether the claim is inextricably intertwined with considerations of the terms of the labor contract. And here, because the claims that the plaintiff relied upon were that the employer violated the collective bargaining agreement, then the court found that adjudication of the Whistleblower Protection Act claim would require determinations of whether or not the collective bargaining agreement was violated. And as a result, because they'd have to determine whether the collective bargaining act was violated, the claims were preempted by the Labor Management Relations Act. Now, the Whistleblower Protection Act, and specifically that Section 837, it includes a term that the Whistleblower Protection Act cannot be construed to diminish or impair the rights of a person under any collective bargaining agreement. Okay, so that was what the court held. Now we are going to talk in a couple of slides. The legislature is not happy about this, but so we're going to see action that the legislature takes in response to that case. But really, if you are an employer who has a CBA, you should be aware of the holdings in Twin River, because it does play a role on how your collective bargaining agreement is viewed with the Whistleblower Protection Act claims moving forward. We saw a significant amendment to the Maine Human Rights Act in 2021 as well, and we became one of only a few states across the country that now includes a protected classification of family status. So the Maine Human Rights Act was amended. It was signed by the governor on June 24th of 2021, and the amendment took effect on September 22nd. And recall that the Maine Human Rights Act applies to all employers with one or more employees. And what they called it, and I struggle with the title that they used, but it was called an act to improve consistency in terminology and within the Maine Human Rights Act. And let's go to the next slide, because I think it's important to see kind of how broad the amendments were. So when they say improve consistency, this is the most pertinent part of the amendment itself. But look at the family status definition. So it wasn't just changed to include language to make it easier to understand. It was extremely expanded. So family status previously had meant a family unit may contain one or more individuals who have not attained 18 years of age and are living with a parent or another person having legal custody of the individual or individuals, or a parent having custody with the written permission of the parent or other person. Family status has now been expanded to not just include a parent-child or caretaker, care provider relationship. So we now have a definition that provides one or more individuals who have not attained 18 years of age and are living with the parent or the designee of the parent or another person having custody with the written permission of the parent or other person. So that includes this could include grandparents, but anyone with legal custody. But then the B1 definition indicates one or more individuals who are 18 years of age or older who lack the ability to meet essential requirements for physical health, safety, or self-care, because the individual or individuals are unable to receive and evaluate information or make or communicate decisions. So previously, if you were an employer with under 15 employees and you had an employee whose spouse was in an accident or otherwise was sick or ill, the Maine Family Medical Leave Act would not be applicable. And you could take action for absences or any other issues. Now, however, the family status definition, which recall is going to apply to any employer with one or more employees, is going to take effect. So if you have an employee whose spouse or someone else who they are responsible for caring for, parent, spouse, any of those individuals who are unable to receive and evaluate information or make or communicate decisions, and they take over that role, you would not be able to terminate, discipline, or otherwise discriminate kind of against that individual as a result of their obligations to do so. You'll see over here in section 4572 subsection 1, in that definition of unlawful employment discrimination, that we had the addition of family status. We also had the addition of gender identity. Honestly, it's not something that we've been focusing on, in large part because gender identity has often, by the Maine Human Rights Act, been subsumed under sex and sexual orientation. So including gender identity is now more specific as to inability to discriminate against an individual based off of that basis, but previously had been presumed in Maine, at least, for it to apply under sex and sexual orientation. We do, however, have this family status language. It's interesting, and this is a little off topic because it's not specifically related to the family status amendment, but we also saw an amendment of the public accommodation language. And the public accommodation language now includes statements that you can't discriminate against an individual on the basis of age. So you can't limit someone's entry or exit into your facility or use of your facility on the basis of age. Now, what the legislature didn't think of clearly was, well, what about bars and nightclubs that may limit individuals from attending events who are under the age of 21 or under the age of 18, or cannabis dispensaries? Those, arguably, you have a violation of the statute every time a bar doesn't allow someone under the age of 21 in. The Maine Human Rights Commission issued a memo indicating that they recognize that there is this issue between the two statutes, and that they won't view it as a form of discrimination. The MHRC's position on it, I think it is appropriate and correct, but the problem is we still have a statute that provides otherwise. So that is the biggest things to be aware of in 2021 concerning the Maine Human Rights Act. Let's jump to 2022. What's pending in Augusta? We currently have a proposal which would prohibit COVID-19 vaccination mandates for the next 5 years, with the purpose to study reproductive effects of the vaccine. It's unclear. Different people are saying kind of how much effort or movement we'll see on this. I think it's unlikely to pass based off of the current makeup of the legislature. We have an act to clarify laws related to the use of medicinal marijuana and workers' compensation. That's LD 1881. That should be on your radar. What it attempts to do is provide that employers must pay for the costs associated with medicinal marijuana if that is chosen over opioids by an employee who experiences an injury. An act to amend the Whistleblower Protection Act to ensure coverage in unionized workforce places. That's LD 1889. That is an attempt to overturn the Twin River Paper Company determination in case that we just spoke about. So it's an attempt to say, even if you have a collective bargaining agreement, the Whistleblower Protection Act is still going to protect you, even if it requires the court to review the CBA in order to determine whether or not you have a claim. We have an act to restore overtime protections to Maine workers, LD 607. And it's interesting because there was significant movement on this bill yesterday. Previously, the labor working group had indicated that they weren't going to take action on this because Governor Mills has indicated that she thinks that this is something that should be occurring at a federal level. And what this is this is an attempt to increase what the salary threshold is for our exempt employees. Unfortunately, however, yesterday the committee voted the bill out of committee along party lines, and they amended what previously had been provided. So what is being proposed now is, we all know currently, in order to determine what the salary exempt number is, it's 3,000 times the minimum wage. We know right now that the minimum wage is $12.75. 3,000 times is how we determine what that salary threshold must be. The proposed new language would increase that 3,000% up to 4,500% over the course of the next 3 years. If the minimum wage stayed at $12.75, which is highly unlikely to, that would mean that in 2025, the salary exempt threshold would be $57,375. And if by 2025, the minimum wage is increased to $15 an hour, it would then result in a salary threshold of $67,500. It would increase each year based off of the increase in what the minimum wage is. So that is LD 607, and it's something that should be on the top of your minds, and something you should be talking to your finance department about as well. We've got LD 965, which is concerning non-disclosure agreements and employment agreements, which wouldn't permit a confidentiality provision in any settlement or separation agreement unless the employee themselves requested it, if there's any possibility of a claim of discrimination in any format. An act to increase the accountability for wage violations, that's LD 616, and that is to increase the current fine from $500 per violation to $2,500 per violation. Act to prohibit employers from retaliating against the use of unpaid leave. And then LD 1463, healthcare coverage more affordable for working families and small businesses. One that's not on here, and the reason I previously hadn't included it is because it was my understanding it was dead upon arrival because Governor Mills didn't support it, and that's LD 225. However, yesterday it was voted out of committee with LD 607, and so the Labor Committee voted in favor of it. And LD 225, what it does is it provides that if an employer provides paid vacation, that vacation time must be paid out to the employee upon cessation of employment. Now, you all know that right now an employer can contract or have a policy about how paid time off is going to be treated. This is an attempt to say that if it's paid vacation, it must be paid upon cessation. When we've talked to the chamber, when we've talked to the legislators, they've said, well, it's just for vacation. So you could call it PTO, you could call it sick leave, you can call it all these other things, and then you don't have to pay it. In my mind, that's not the way the Department of Labor has previously viewed earned, PTO, vacation, sick bank, those type of paid leave programs. So we need to keep track of 225, because if it does end up being passed by the legislature and not vetoed by the governor, the recommendation would likely be to change the name of any paid leave you provide from vacation to PTO to get around this law. We've got a couple minutes left to talk about what's going on from a federal level. We're still talking about COVID, so let's jump right there. So, as many of you know, last week the United States Supreme Court issued its opinion, which stayed OSHA's 100+ ETS. We're currently waiting to see if OSHA is going to withdraw the ETS, or if they're going to attempt to litigate in the Sixth Circuit concerning why they believe the ETS is proper. At this point in time, however, OSHA's been stayed, the provision isn't in effect, so you don't need to be worried about kind of having that policy in place under OSHA. The CMS mandate, however, that was upheld by the Supreme Court. So if you are a receiver of Medicare funds, you need to be complying with the CMS mandate. As to the federal contractor mandate, we have split operations here in Maine. If you're a federal contractor, there is no stay in effect. If you are, federal, I apologize. Okay, we have a split contract. For a federal contractor, okay, we have split jurisdictional determinations, but we do have a nationwide stay that's in effect. So the Southern District of Georgia has issued a nationwide stay. It's also been stayed by Kentucky, Ohio, Tennessee, Missouri, Nebraska, Alaska, Arkansas, Iowa, Montana, New Hampshire, North Dakota, South Dakota, Wyoming, Florida, Louisiana, Indiana, Mississippi, Texas, and Arizona. And the reason why that's important is because if the Southern District of Georgia's opinion is overruled, then we would no longer have a stay here in Maine, but New Hampshire would continue to have a stay, and many other states would continue to have a stay because there's a double stay that's been issued. Best practices generally, however, so we know the OSHA mandate has been stayed, but this is the first time that we have gotten guidance specifically from OSHA about best practices. Keep that in mind because we know we still have the general duties clause in effect. So you know that you have a general obligation to provide a safe and healthy work environment for employees. This would indicate that having some form of a COVID policy in place is important. Keeping employees who have COVID out of work is going to be an important element of that. Following CDC guidance concerning vaccinated and unvaccinated employees, masking in the work environment for your unvaccinated employees. All of those are, are low cost ways in which you can still be protecting the health and safety of your employees, and that are supported by OSHA. So keep that in mind. There are, a number of wage and hour questions related to COVID-19 that we're seeing a lot of. We have a lot of employers who, even though the OSHA mandate has been stayed, are considering or have decided to move forward with the same standard, or have created a vaccine mandate without the testing alternative. Be mindful of the costs associated with the tests themselves. The Maine Department of Labor has indicated that the employee can be required to pay for the costs associated with the test. And the reason for that is because it's not required. It's an alternative to being vaccinated. We question or ponder that if an individual is entitled to a religious or a medical accommodation. I think it's a bigger question as to whether or not the employer has to pay. If you have a workforce where you're paying at or around minimum wage and there's costs associated with weekly testing, be mindful that that cost doesn't bring the employee's wages below minimum wage and you potentially have a wage and hour violation. We've got a few more minutes. So I just want to talk about employee mobility. This is, I think, a great chart from Bloomberg that discusses the work from home and the percentage of people who we are seeing working from home. I mean, prior to 2020, we saw so few. We saw, only a few percentage of people working from home. And now we're staying consistent right here at around 40%. What does that mean kind of generally for us? Be mindful of how you're hiring and attracting and retaining your employees. So jump to that next slide and understand your obligations from an I-9 standpoint. If you have remote workers and your ability to have verification of employment documents and how you're getting those into your records, you need to have a remote work policy in effect at this point in time. In that policy, consider safety implications and security implications. Do you have confidentiality agreements in place? Do you have policies in effect to be able to remotely turn off access to individual files and workspaces? From an electronic monitoring standpoint, if you are an employer who monitors employee keystroke or visually monitors, be very mindful of state law. Now, state law becomes really important because we need to know where an individual is working. We have a ton of situations lately where an individual's residence may be in Maine, but come to find out they've been spending the summer in Arizona, and for the last 4 months they've been working from Arizona. This could have tax implications for the organization. So it is important that in any remote work policy that we set up a provision where they tell us where they're going to work, or that we provide that the remote work must occur at one of these 3 states or in one of these locations. Another big concern is wage and hour implications for our non-exempt employees. So tracking time and expense reimbursement should be things that you are considering and keeping at top of mind, making sure we're paying non-exempt employees for all time in which they've worked. I told you we were only going to talk about the National Labor Relations Board if we had sufficient time, and unfortunately we don't. So that is the end of the presentation. I want to be mindful of everyone's time. Thank you so very much for your attention. I'll be around for a couple of minutes if you do have additional questions, but otherwise I look forward to seeing you this afternoon if you have operations in Massachusetts or in Connecticut. Otherwise, stay safe and healthy.